Hi, thanks for joining us. I see that people are just hopping on right now, so I'm going to let a couple more people get on before we get started. All right, I'm going to go ahead and at least start with the announcements. Welcome to today's CLE program. My name is Anna Mancini. I'm chair of the DCBA Immigration Law section. If you're interested in being part of the leadership for the immigration section, and I'm just going to throw out there, this is off script, but we don't have a co-chair this year, so it's super important we try to find someone for next year. Or if you're interested in any section, division, or program of the DCBA, we need to hear from you. You can find more information and a link to the self-nomination form at the bottom of page 2 of today's agenda. Free CLE credit is a major benefit of being a DCBA member. Beginning October 1st, non-DCBA members attending noontime CLE will be able to receive credit when paying a $40 registration fee. It is important that DCBA members sign in on the DCBA website before registering for a CLE program to avoid being charged the $40 fee. The newly updated DCBA website allows you to save your username and password, so signing in and registering for a CLE is easy to do. If you are not signed in, you will see a $40 charge to register. When logged in, you will see your registration is free, as it always has been. Please note, in April, we will meet on our regular day, the second Wednesday of the month, which is April 13th. Allison Peck, professor from West Virginia University College of Law, will be talking to us about the immigration courts, past, present, and future. As always, please make sure you complete the evaluation to receive your CLE credit. You will receive an email near the end of today's program reminding you to complete the evaluation by 5 p.m. on Friday, as this is the only way to receive credit for attending today. You can also find a link to the evaluation on page 1 of today's agenda. You can find attendance certificates for all DCBA CLEs in your member profile by following the instructions on page 2 of today's agenda. Please note your certificate can take up to a week to appear in your profile. For today's program, please ask questions via the Q&A box rather than typing them in the chat box. And so now we'd like to get to today's program. Today we have Akua Aboagye. She is the founder of Poku Law. She is licensed to practice law in 2 continents, North America, New York, and Africa, Ghana, West Africa. As an immigrant herself who has experienced firsthand her own unique immigration story, she has chosen to focus her practice on representing immigrants and on giving them excellent legal representation, primarily in their U.S. immigration matters. She is based in Northern Virginia, but represents many immigrants throughout the United States and around the world, regardless of their location. Welcome, AK, and I'm going to turn it over to you.
Thank you so much, Anna. Thank you. I appreciate it. Well, thank you, everyone, for joining us in this presentation. I hope to make it as exciting and as engaging as possible, because I know this is quite a complicated topic, because it's an intersection between U.S. immigration law as well as international law. So I hope that we'll all benefit from this. Okay, so let me get started. I hope everybody can see and hear me. I cannot see anybody else apart from myself and Anna. So I hope all the participants can see me. Okay.
We can hear you and see your slide as well.
Okay, perfect. Okay, so U.S. citizenship. How do you acquire U.S. citizenship by birth in the United States? This is Push and Flight. And let me give my... Okay, let me shift this. So good day, ladies and gentlemen. Welcome on board this flight to the United States of Immigration Law. My name is Attorney AK. I'm your in-flight service director. I'm here to ensure you have an enjoyable flight. Now fasten your seatbelts as we take off. Okay, so imagine yourself in a window seat. You're buckled up mid-air, hours into your international flight, almost due to land. The flight's final destination is the United States. As the plane tumultuously makes its way in the dark of the night towards his final stop over an unrecognized ocean, bumping on clouds with you drifting in and out of sleep, you hear moans. Ears playing tricks? No, the moans are getting louder and very unmistakable. Sounds like someone in pain. Gasp, labor. You perk up your ears, hear harsh voices, and see the silhouettes of hurried flight attendants scurrying around through the apprehension and uncertainty. There's an announcement made in an urgent voice over the speaker. Any physician or nurse aboard? More scrambles, longer and more excruciating moans. You hear the word push, then the screeching cries of a newborn baby. Applause from the passengers who are all now awake and alert, feeling quite privileged to have witnessed this rare airborne event. Everyone is elated. Mommy and baby are doing fine. You look out the window, the plane is still flying over a very large ocean. A wild thought comes into your head. What in the world is the citizenship of this baby? Okay, so we'll discuss a bunch of things in the CLE. I don't believe I should go through all of this because I believe all of you have the slides, but we're going to take a look at this within the context of a story that went viral in the last 2 months. It was of a mother who was flying from Ghana to the US. Ghana is my home country, and they were almost 2 hours. They had almost 2 hours to land in the United States, and the mother, the mother gave birth to the newborn baby. And so I had a bunch of questions following that. What was the citizenship of this baby having been born, mid-air? Okay, so we'll take a look at that, and then we will focus more on the principles of jus soli, ways to acquire U.S. citizenship. We'll take a look at the 14th Amendment of the U.S. Constitution, and then a few other definitions according to law. So we'll look at the U.S. Constitution, the Immigration and Nationality Act, the Foreign Affairs Manual, and then the UN Convention on Reduction of Statelessness of 1961. Okay, so let's get started. So U.S. citizenship can be acquired either at birth or after birth through a process known as naturalization. Okay, so if you acquire it at birth, then you can acquire it in one of two ways. In the US, so many different countries have, their laws for how to acquire citizenship at birth. Some countries go with the jus soli principle, some countries go with the jus sanguinis principle. Okay, so there are two fundamental common law principles with citizenship at birth. Jus soli means the law of the soil. It means that if a baby is dropped on the US soil, then the baby is a US citizen, okay? And with a jus sanguinis principle, it means that the baby would acquire citizenship of the country of his mother, of his father, or perhaps of his grandparents. For the US citizen, for the United States, both principles apply for citizenship. So in the US, if you are born on US soil, then according to the Constitution, the US Constitution, the 14th Amendment, then you are a US citizen. Again, the United States also follows the jus sanguinis principle. And so even if you're not born on United States soil and you're born abroad or wherever, insofar as both your parents or one of your parents is a US citizen, then you acquire citizenship by the bloodline. And it's very interesting to note that the principle of jus soli is actually enshrined in the US Constitution. And we know that the Constitution is the supreme law of the land. And so it's very fundamental. However, the principle of jus sanguinis, which means that when when somebody acquires United States citizenship by the blood, that is actually acquired through statutes. So statutes, the Immigration and Nationality Act, Section 301, is what codifies this principle, this common law principle. Okay, now let's take a look at, so as I stated, acquisition of US citizenship subsequent to birth is known as naturalization. So for example, I was not born in the US, so I acquired my United States citizenship through a process known as naturalization. So it's after birth by any means whatsoever. Okay, so now let's take a look at the principle of jus soli. The the 14th Amendment. So it says that Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Okay. Now let's skip to the INA, the Immigration and Nationality Act, Section 301, which says that a person born in the United States and subject to the jurisdiction thereof is a national and a citizen of the United States at birth. So I've rephrased it, but I believe it has the same import. Okay. Now let's take a look at some practical examples from other countries. So, for example, as I stated, United States follows the two principles, both the jus soli principle and the jus sanguinis principle when it comes to acquisition of United States citizenship. For example, in France, when in France there's no jus soli principle. Again, in Germany, German citizenship is not acquired by jus soli, it's acquired by descent. In France also, it's acquired by descent. Okay, and then in my home country, Ghana, citizenship is also acquired by descent. So there's no jus soli principle. In Ghana, the 1992 Constitution, Article 6.2 says that on the date of a child's birth, if either of his parents or grandparents is or was a U.S. citizen, was a Ghanaian citizen, then the child acquires Ghanaian citizenship. So it's very similar to the jus sanguinis principle of the United States. Okay, so the other thing to note also is that birthright citizenship, which is the jus soli way of acquiring citizenship, is a rare policy throughout the world. It's just roughly about 33 countries in the world that practice the jus soli, or the recognize the jus soli as a way to acquire citizenship. So now let's take a look at some countries that recognize the birthright citizenship. That's citizenship through the soil. If you are dropped on the soil of these countries, then the baby acquires U.S. citizenship. So Antigua and Barbuda, Argentina, United States, Canada, and then Venezuela. So here's a fun fact. So former President Trump, he spoke about doing away with the jus soli principle for the U.S. According to him, he believed this was a threat to national security. This is because just anybody at all can come to the U.S., whether they want a B1 visa, regardless whether they want a non-immigrant visa or they were undocumented or whatever, and then they could deliver their babies, and the babies would be U.S. citizens. And once a baby is a U.S. citizen, the baby is known as an anchor baby, right? Because the baby can grow up, and by the time the baby turns 21 years old, the baby can file for his family, his mother, his father, his spouse, his children. And so there's that train there. But that didn't happen. So it's still pretty much enshrined in the Constitution and the US Constitution. So here's another super fun fact before we get into the juice of everything, the more complex discussions. So generally, if a baby is born on a flight, there's a very good chance that the baby could be born over the ocean because apparently the earth is made up of about 70% to 73%, or even some people say 75% of water. Okay, and then just about 30% is land. So if you're flying, perhaps you're flying over a large ocean, and the baby would be born over an ocean, could be born over. Okay, so you guys know that lawyers are very complicated. Even when we define, we have definitions in statute or in law, we have to define those definitions. So if you remember, I spoke about the fact that if you're born in the United States, then you acquire citizenship. But then an argument could arise. What does birth in the United States mean? If a baby is born on the border of the US, or a baby is born at a US embassy abroad, does that count as birth in the United States within the, for the purposes of the 14th Amendment? So now let's take a look at what birth in the United States is defined as. So INA, Immigration and Nationality Act, Section 101 defines it. It's when used in a geographical sense, the term United States means the continental United States, Alaska, Hawaii, Puerto Rico, Guam, and the Virgin Islands of the United States. So pretty much it simply means the US and its territories. That's what birth in the United States means. And so we're going to be breaking down what the confines of this definition some more. Okay, so the other thing to also note is that when we talk about a baby being born in the US, they only acquire US citizenship if they are subject to the jurisdiction of the United States. What does this mean? So for example, we know that diplomats are not subject to the jurisdiction of the United States. Okay, so a diplomat would usually not be held criminally liable because they're just not subject to the jurisdiction of the US. And so, for example, if a diplomat is delivered of a baby here in the US, the baby would most likely not be a US citizen because they're not subject. The diplomat mother may not be subject to the jurisdiction of the United States. That's an exception. Okay. And the other thing is that all children born in and subject at the time of birth to the jurisdiction of the United States, they acquire citizenship at birth, even if their parents were in the United States illegally at the time of birth. So it doesn't matter whether, as I mentioned before, the immigration status of the mother of the baby is irrelevant. This principle is absolute. Of course, apart from the fact that you have to be subject to the jurisdiction, there are no ifs and buts. Even if the mother is on a visa or it's an expired visa or whatever, the child, just by reason of the fact that he's dropped on the United States soil, the baby becomes a US citizen. He acquires citizenship by birth. Okay, now this principle was espoused in the case of the Supreme Court decision of US versus Wong Kim Ark. And in that case, I believe I have some notes here. I wonder why I can't show that. Oh gosh. Okay, I don't think I can show it while it's, but let me tell you about that case. It was about a Chinese couple, right? And they were here in the United States, and the parents were ineligible for citizenship based on some statute or treaty that existed at the time. And so the couple gave birth to a baby boy here in the US, and then they left. They left back to China. And I believe after some 20 years, when Wong was 21 years old, he left the US, went to China to go visit his parents. When he was coming back at the border, they told him that he was not going to be allowed into the US because he was not a US citizen. The US Supreme Court disagreed vehemently. It stated that regardless of the fact that his parents could not ever acquire US citizenship, Wong, by reason of the 14th Amendment or the jus soli principle, was a US citizenship because he was born in the United States. End of story. Doesn't matter, what his parents did, whether they were detained, whether they were out of status, whether they were undocumented or whatever. Okay. So that's okay. Now let's take a look at not included in the meaning of in the United States. So again, as you know, as lawyers, we have the rules, and then we have the exceptions and the exceptions and the exceptions and the exceptions and the exceptions. So we're going to be looking at what does it mean, we have in the United States, but there's still things that are not included in the meaning of the United States. So the first thing is that there are certain geographical areas that are not included within the meaning of the United States. I will show you a diagram later. I'll show you, it will make more sense when I show you the diagram, but let's go through this. So if there's a US registered or a documented ship on the high seas or in the exclusive economic zone, and a baby is born, even if the baby is born on a US registered vessel and the baby is born in the high seas or in the exclusive economic zone, then the baby is not a US citizen. Please follow me. We are going to connect, this discussion, the birth, as it relates to the sea, the high seas, to the territorial airspace. It's a very interesting connection. So follow me, and you'll soon get the nexus. Okay. So when we talk about okay, let me start from this. We have the United States, and then we have the internal waters. Okay, the internal waters are usually the enclosed areas of, the bay, the ports. We'll define all that later. But the internal waters forms part of in the United States for the purposes of the 14th Amendment. From the internal waters or the internal seas, we move to the territorial seas. When you measure that, it is normally 12 nautical miles from the coastal baseline of the United States. And initially, it was 3 nautical miles, but that was extended in the late 1980s, I believe. So when we talk about the territorial sea, it's after the internal sea. The internal seas, no measurements. The territorial seas are 12 nautical miles from the coastal baseline. From the territorial sea, we go on to the exclusive economic zone. The exclusive economic zone is normally 200 nautical miles from the coastal baseline. It's not part of the United States. Then we move on to the high seas, which is also not part of the United States for purposes of the 14th Amendment, okay? So now let's talk about this. Even if the baby is born in a US registered or documented ship and it's on the high seas or exclusive economic zone, the decisive factor is the space, the soil. Those places are not the soil. You're not dropped on US soil if you're dropped on the exclusive economic zone. So it doesn't matter that you're born in a US registered vessel. Law of the soil, you are not a US citizen, okay? Because those areas do not form part of the US territory. Now let's take a look at this. If it's a US registered aircraft and it's outside the US airspace, it's not US territory. Okay, so again, as I said, it's a US plane, not in the US airspace. Baby is not a US citizen. Now, there's a UN convention on reduction of statelessness, the 1961 Act, and Article 3, the convention. Article 3 of the convention actually states this. For the purpose of determining the obligations of contracting states under the convention, birth on a ship or in an aircraft shall be deemed to have taken place in the territory of the state whose flag the ship flies, or in the territory of the state in which the aircraft is registered, as the case may be. So, as you guys know, being stateless means that you don't have citizenship. You don't have any type of citizenship. And this convention aims to reduce statelessness, because remember that there are some babies that could be born in the air. And if they are born mid-air, and for example, they are on an ocean where it's not any state territorial airspace, then they have to resort to the aircraft, the nationality of the aircraft in which they are flying. Okay, so for example, imagine a German, let's say a German mom or any citizenship, and they give birth on Lufthansa. So for example, if you give birth on Lufthansa and it's not on the territorial space of any state, then the baby will take on the citizenship of the aircraft in which they are born. Being a citizen of a nation gives you an identity, a sense of identity. It gives you the privilege to enjoy rights that come with being a citizen. You feel a sense of belonging. So they aim to reduce this. And so they try to bridge the gaps that have been produced by, complicated international law by this convention. And, this convention has to apply to parties that are signatories to the convention. So for example, the United States is not a party to the convention, to the UN Convention on Reduction of Statelessness. So even if the baby is born on Delta Airlines or United Air, the baby is still not a US citizen so far as the baby was not born in the US airspace. Okay, so parties to the convention are UK, Nigeria, Togo, the Netherlands. So if, for example, the baby is born on Alitalia, that's an Italian airline, then most likely the baby could acquire Italian citizenship. If the baby is born on let's say, British air, then the baby could acquire British citizenship if the baby is born in an airspace that does not belong to any country. Okay, now let's move on. Okay, so again, we still continue with what's not included in the meaning of in the United States. So despite widespread popular belief, U.S. military installations abroad and U.S. diplomatic or consular facilities abroad are not part of the United States within the meaning of the 14th Amendment. So there are people that would, I heard this in the past, if you're heavily pregnant, they'll tell you, well, time your contractions, and as soon as you feel them coming, run to the U.S. Embassy in Nigeria or in Tokyo or in Ghana and go and deliver on the premises, and your baby, voila, baby gets U.S. citizenship. Unfortunately, you will just be endangering the life of mommy and baby, because that is not included in the definition. A U.S. diplomatic or consular facility abroad is not the United States within the meaning of the 14th Amendment. Okay, now, again, I remember we touched on subject to the jurisdiction of. Let's talk some more about this. So if you give birth on a private ship, and this is done in the US, this happens in US internal waters. So a child born on a foreign merchant ship or privately owned vessel in the US internal waters is considered as having been born subject to the jurisdiction of the United States. So again, remember the decisive factor is on what soil. It's in US internal waters. Remember I explained to you that US internal waters is in the United States for the purposes of the 14th Amendment. So if you are born on a foreign merchant ship, so imagine that, let's say me, I have a bunch of friends, let's say from Germany, and we are on a yacht, and the yacht is owned by another attorney, who happens to be my friend, and he is German and he owns the yacht, right? And we happen to be sailing in US internal waters, and we have one other woman lawyer who happens to be pregnant, join us on the trip, and she delivers. Despite the fact that the child was born on a foreign merchant ship or even a privately owned vessel, insofar as that baby was born in US internal waters, then the baby is a US citizen. So he's said to have been born subject to the jurisdiction of the United States, because being born in the US internal waters makes you subject to the jurisdiction. However, there's an exception. If it's a foreign warship, naval auxiliary, or other vessels that's owned or operated by a state, and it's used for governmental, non-commercial service, then the baby is not subject to, well, then again, the baby is not a US citizen, because the baby would not be born subject to the jurisdiction of the United States, even if the baby is born in internal waters, if it's a foreign warship and the like. Okay. Oh, I skipped this. Oop. Okay. Now to the connection. Let's take a look at these principles. So what does birth in US internal waters and territorial sea mean? Excuse me. So there are two principles. The first principle is that under international law, the limits of a country's airspace will correspond with the extent of its territorial sea. That's why I went through pains to explain the limits of the territorial sea, because remember that if the US, the limits of the US, okay, I guess you guys cannot see my illustration, but the limits of a country's airspace will correspond with the extent of its territorial sea. It's easier because you can actually measure the territorial sea much better than you can measure the air, right? So you kind of want to see, okay, what's the measurement from the coastline to the sea? And then we correspond that, we use the extent to be able to measure, the extent of the airspace, because that there's a correspondence. It has to be the same. Okay, then the second principle is that in property law, there's a Latin maxim, cujus est solum est usque ad colum. So this rule means that he who possesses the land possesses also that which is above it. And other elucidations are that he who owns the soil owns everything above and below, from heaven to hell. Okay, so now the question is, in fact, let me give you guys an example of this principle. So if you have your house, and once you have your house here, the airspace belongs to you as far as you can use it. So you cannot have your neighbor actually build into an extension of your airspace. That's not allowed, right? So that's just for illustration purposes. Now, the question is, if birth occurs in U.S. internal waters and territorial sea, is this birth in the U.S. for purposes of the 14th Amendment? Okay, so I believe we've already discussed this. When we talk about the internal sea, U.S. internal sea is in the U.S. for purposes of the 14th Amendment. So internal waters include the ports, the harbors, the bays, and other enclosed areas of the sea along the U.S. coast. So if you give birth in the U.S. internal waters, then the birth is in the U.S. and the baby is a U.S. citizen. There's no measurements as to what constitutes internal waters. I believe I mentioned that again. I think we discussed this. Let me move on so that we have time to take questions. Now, the 12 nautical limits. Okay, so I mentioned this. Now, the territorial sea of the U.S. extends 12 nautical miles from the baseline of the U.S. And this is determined in accordance with international law. So 1 nautical mile is equal to 1 mile. Nautical miles is the measurements for the sea and waters. So people believe that there's still a substantive legal question as to whether a person who is born outside the internal waters but within the territorial sea is in fact born within the United States. Okay. I tried to share a diagram so that this will be clearer, but this is not too clear, but let me still mention it. So there's a part that is not showing, that's the internal sea. Okay, internal waters. So imagine the United States map on the left, and then the internal sea being the enclosed space. Immediately after that, we have the territorial space, which is 12 nautical miles from the baseline. Then we have the exclusive economic zone, which is 200 nautical miles, and then the high seas. So the exclusive economic zone and the high seas are not birth in the US if the birth happens within the airspace of those areas. And remember that the extent of the airspace corresponds with the territorial sea, okay? Okay. According to the Foreign Affairs Manual, if you give birth, and this is outside the internal waters, but within the US territorial sea, you have to email the US government for a determination. They would adjudicate as to whether the baby is a US citizen or not. Okay, so now what is birth in US airspace? Again, as I've mentioned already, under international law, the limits of a country's sovereign airspace will correspond with the extent of its territorial sea. And the outer limit of the territorial sea of the US is 12 nautical miles from the coastline. Airspace above the land territory, the internal waters, and territorial sea is considered to be part of the United States. So if a child is born on a plane in the US or flying over its territory, so if a child is born in the US or it's flying over the internal waters or territorial sea, then it's most likely that the child acquires US citizenship. Okay, so the principle is that the limits of a country's airspace correspond with the extent of its territorial sea. I skipped that. Okay, I think I mentioned this already. Also, aircrafts have the nationality of the state in which they are registered. And sometimes what could happen is the nationality of the aircrafts, the nationality law of the aircraft's nationality may be applicable. And for births that occur in flight while the aircraft is not within the territory or airspace of any state, it is the only applicable law that may be pertinent regarding acquisition of citizenship by place of birth. However, if the aircraft is in or is flying over the territory of another state, then that state may also have concurrent jurisdiction. Okay, so again, this is to prevent statelessness. If the aircraft is flying within a space that is not within the territory of any state, then we resort to the nationality of the aircraft. So for a baby born on, again, Lufthansa, German, I can't remember, so KLM will be a Dutch citizen if the aircraft is being flown on, you know, a territory that does not belong to any nation. Okay. Again, well, there's something I believe I must have left out, but let me still talk about it. Under the you know, the reason why we sometimes have the law of statelessness is that imagine a country like my home country, Ghana, which does not allow jus soli. So if you're a foreigner and you deliver on, you know, in Ghana, the baby is not a Ghanaian citizen, okay? If the foreign mother also happens to be from, for example, Malaysia or Lebanon, then the baby is without a state because those countries do not allow transmission of citizenship if the birth happens abroad. So this law on the reduction of statelessness helps to kind of bridge those gaps where it applies. So that's just an example to give you an idea of how somebody can end up stateless. It's very possible. Okay, now what is birth in U.S. airspace? So cases of citizenship of persons who are born on planes or airspace above the U.S. land territory or internal waters may be adjudicated by passport specialists at domestic passport agencies and centers or consular offices and posts abroad. Okay, so if a baby is born outside the 12 nautical mile limit, that will be adjudicated as a birth abroad. We have the CRBA process, which is the consular report of birth abroad. That's covered by Section 301 of the Immigration Nationality Act. So if you are a U.S. citizen and you're a mother and you deliver abroad, let's say in Germany, because you didn't deliver, you know, the jus soli principle will not apply to you because you didn't deliver here. You will go to the U.S. Embassy in Germany and then report the birth. And that's how your child will obtain his citizenship. So that's the CRB, consular report of birth abroad. So if a baby is born outside the territorial sea, then it's a birth abroad, according to the law, okay? Then cases of persons who are born on a plane in airspace above the U.S. territorial sea must be referred to this email, the ASCII PTA adjudication at state.gov for consultation with the legal advisor of Office of Consular Affairs. Okay, now we're, I believe we're almost at the end. So documenting birth abroad, well, birth in U.S. waters and U.S. airspace. Proof of birth in U.S. internal waters or airspace, you need to, well, it consists of a U.S. birth certificate that has been certified by the issuing authority in the U.S. jurisdiction. And so normally you would need, if the baby is born in an airplane and you're saying that the baby was born in the United States because the baby was born within the territorial airspace of the U.S., then you'll need the aircraft's medical log. And this medical log should reflect the time the baby was born, as well as the longitude and the latitude where the birth occurred. And once they have that, they will be able to properly adjudicate. Well, they'll be able to, if it's within the territorial airspace, then there's no adjudication because it's clear. Of course, when there's a gray area, then there'll be adjudication. But otherwise, this would just be for purposes of documenting that the birth actually occurred within the U.S. airspace. Aircraft inbound for the United States, then the parents would be responsible for reporting the birth to the civil authorities in the U.S. jurisdiction. Okay, and then okay, so the babies, well, the parents will have to contact the State Vital Records Office to determine the exact procedures for reporting such a birth. Again, this is from the Foreign Affairs Manual. It's a policy, the Foreign Affairs Manual is, you know, it contains policies, regulations that help regulate the actions and the you know, the duties of the Department of State, as well as Foreign Service and some federal agencies. So you contact the SVRO for the procedure, you contact the State Vital Records Office, and then you will determine how exactly this should be recorded. The truth of the matter is this subject is it doesn't happen, this doesn't happen often, you know, birth in the airspace. So it looks like a lot of things are not concretized, you know, because it normally, even to fly when you are between 28 and 36 weeks, you need a letter from your physician. Not many doctors will allow you to fly. So giving birth, you know, within the airspace is not a very common occurrence. Okay, so that's why the topic seems to be very, you know, it's quite complex. And then let's see, so if the mother and child were immediately taken to a U.S. hospital, authorities there may be of assistance in facilitating contact with the appropriate state authorities. And I believe there's another thing I missed here. Parents should do well to make sure that they obtain the certified copy of the airplane's log for our purposes, or other statement from the attending physician or other attendant, and then how to contact these attendants in the future if you know, these authorities have questions for the attending physicians, you know, about how the birth occurred and what happened. Okay, so I believe we're done now. I hope I haven't left out anything. I don't believe so. Okay, Anna.
Okay, so I'm just looking to see if we have any questions or anything. Let's see. So here is a hypothetical. Applicant claims they were born within 12 miles of US on a flight. Immigration official claims that the applicant was born 20 miles of airspace. Who bears the burden of proof?
Okay, so the applicant is saying that they were born within 12 miles.
Yes. So I guess basically the question is, when we're adjudicating claims for birth in airspace, who bears the burden of proof on that? Is it the applicant who has to prove it, or is it the US government who has to disprove their claim?
Okay, so normally one very fundamental US immigration law principle is that it is borne by the benefits requester. So he who is seeking the immigration benefits bears the burden of proof, you know. And again, normally that burden is by a preponderance of the evidence. That's the general burden. That burden can change depending on the type of immigration benefit you are seeking, or, you know, so for example, if you are in immigration court and you get married and you're trying to adjust your status, you need to demonstrate by the clear and convincing evidence that you entered into the marriage, not just to obtain immigration benefits, but, you know, to actually establish life together. But the general standard for US immigration applications or requests is by the preponderance of the evidence. And case law has also established that by the preponderance of the evidence means that more than a 50% chance of that thing happening, or that it's more than likely than not that it happened. So in this case, I believe the parents are the ones seeking the immigration benefit of citizenship for their baby. So they will bear the burden. And so it's on to them to make sure that they obtain the aircraft's medical log, which will contain the reflection of the time, the latitude, and the longitude wherein the birth occurred. And if the birth occurred in the internal seas, then the baby was born in the US. Within 12 miles from the baseline, that's still the territorial sea. I believe your question said 12 miles?
Yeah.
Yes, so 12 miles, it's still within the territorial sea. So the baby was born in the US, but the parents bear the burden, they need to demonstrate. If it's 200 nautical miles from the coastline, that's the exclusive economic zone, that is not US territory, baby was born abroad. If it's on the high seas, not US territory, baby was born abroad. So if it's within the airspace of the high seas, or remember the common law principle that the measurement goes as far as horizontally. When it comes to vertically, It's all the way up to the heavens, all the way down to hell. So insofar as horizontally, it's within 12 miles. It doesn't matter how high up the plane was or how low, the baby would have been born within U.S. territory.
All right, so we have another question. Suppose two U.S. citizens give birth to a baby. So I'm guessing mom and dad are both U.S. citizens, and mom gives birth to a baby in the center of the Atlantic Ocean on United Airlines. What's the citizenship of the baby?
Okay, so in the center of the Atlantic Ocean, but again, what is the measurement? We have to know the measurement because that's how to define what the citizenship of the baby is.
Well, I think partially this is also like a law school question, because we're assuming two U.S. citizens gave birth to the baby. So if a U.S. citizen gives birth wherever they give birth, it's a U.S. citizen.
Absolutely, yes.
But he said, let's change it up a little bit. What if both parents are stateless? And when he says stateless, he means, for example, they were born in a country that no longer exists, like Czechoslovakia. So if the baby's born to two U.S. citizens, they're clear to any U.S. citizen, they're clearly a U.S. citizen. But what if their parents are stateless and the baby's born on that airline in the middle of the Atlantic Ocean?
Okay, so let's take it step by step. As we started by saying that if a baby is born to U.S. citizens, if it's not on U.S. territory, then the baby would not acquire citizenship by the principle of U.S.A. So again, they'll acquire it through the law of the bloodline, through their parents, as you rightly said. Now, if both parents are stateless and the baby is born on U.S. territory, so if they measure where the delivery occurred, and that measurement falls within 12 nautical miles from the baseline, it goes up. Then the baby acquires U.S. citizenship, regardless of the fact that her parents are stateless. Remember U.S. versus Wong? The Supreme Court espoused the principle. Don't look at the parents, doesn't matter. The principle of jus soli is fundamental, is the 14th Amendment. Baby dropped on U.S. soil in U.S. territory, baby is a U.S. citizen. So depending on where this middle of the Atlantic Ocean is, if it's within the U.S. territory, then the baby would be a U.S. citizen.
So I guess maybe the question is, what if it's not? What if it's too far away from the U.S. to be in the U.S. territorial waters?
Oh,
hard question.
Yeah, but the baby is going to be stateless, because remember that we spoke about the fact that the United States is not a party to the UN Convention on the Reduction of the Law of Statelessness, 1961. Article 3 clearly states that if the baby is going to be stateless, then the baby will take on the citizenship of the aircraft or the ship or the vessel, the nationality of the aircraft in which the baby is born. If the baby was born in a United Airlines aircraft, then the baby should be American. But the US is not party to the convention, so, and if the baby is born outside US territory, then there's nothing we can do, clearly then the baby is going to be stateless, which happens. But let's take a look at another scenario where the baby, the parents are stateless and the baby was born in, let's say, in KLM. We go back to the UN Convention on Reducing Statelessness. The baby will take on the citizenship of a Dutch person, because even though the baby was not born within any airspace, we fall back on the Dutch citizenship. If it so happens that that will coincide with another country's airspace, then the baby can have concurrent citizenship if both countries allow dual citizenship.
All right, so I think the lesson here is if you're pregnant, you're going to fly, don't fly on a U.S. airline. I'm waiting for other questions, but till then, I want to go back to something else that you raised, and it was the concept of changing the 14th Amendment to get rid of birthright citizenship. I mean, as we've seen these last few years, things that we thought would never happen in immigration and in other areas of our lives actually have happened. So what are your thoughts on getting rid of birthright citizenship? What are the pros and cons to the United States?
Okay, so if you take a look at the Federal Register, this issue was, well, revisited, I believe, in 2019. And the Federal Register is kind of the register that gazettes statutes and laws and kind of explains Congress's intent for, actually implementing statutes. And what is said was that they were going to actually find ways to make sure that birthright citizenship was protected and that it remains unblemished. Okay, so what people do is that, well, we all know that around the world, United States citizenship is very highly coveted because of the American dream. Everybody wants to come, well, not everybody, but most people want to come to the US and become US citizens. And again, because of the United States versus Kim Wong, the Supreme Court case we talked about, it does not matter if somebody is just here on a temporary visit or whatever. Insofar as a person delivers in the US, the person's baby gets US citizenship. And so this is actually being looked at from the consulate. They're trying to seal all the gaps from the front end. And so back, all around the world, all the US embassies have been given the directive. Well, again, you cannot discriminate, for example, against pregnant women. So somebody cannot come to the embassy and say, I want to visit the US, and then you say, are you pregnant? That's not allowed. However, the consular officers have discretion to deny visas to people that they believe are pregnant and are just coming solely for the purposes of getting US citizenship. So it's a very dicey matter because pregnant women can still come to the US to conduct their business. They can still come here to visit family and friends, right? You don't want to discriminate and say, oh, nobody should come if they are pregnant. That will not be fair. So it's a very dicey matter that has to be handled well. And so they're trying to seal, again, the loopholes from the consulate, making sure that people who are granted visas are not coming just for birth tourism purposes. I remember reading in the Federal Registry, they gave an example of a woman who actually came to the US. I believe she was from, I read this a very long time ago, but I think she was from Asia, one of the countries from Asia. And she happened to be a woman of a lot of means. And her birth cost around maybe $40,000 or $50,000 thereabouts. She only happened to pay about $3,000 of the bills. I can't remember the exact figures. And then the US government realized that she had bought luxury goods like Louis Vuitton bags. They stated all this in the Federal Register, costing about $19,000, and she didn't pay for her birth, right? So it was clearly concerning to the government that this law is being taken advantage of. But at the same time, it's a fundamental, once a statute, once a law is contained in the supreme law of the land, it means it's highly recognized. Being in a law being in a constitution, that's pretty weighty. So even though it has its cons, it's still fundamental to, it's a fundamental law to allow people who are born here to be US citizens. So I guess the work has to be done around the US embassies and again at CBP, at the Custom and Border Protection, because sometimes what happens is people don't take the visas right before, maybe 4 months before they deliver. Sometimes they'll take it 3 years prior to getting pregnant. So at the port of entry also, they check all those things. They ask questions. What is your primary purpose? Again, there's a primary purpose test. If you are coming, for example, on an F1, your primary purpose should be to study, not to deliver, right? If you're coming on a B1 or B2, your primary purpose is for tourism and not to kind of deliver a baby and give them US citizenship. So it's a difficult topic.
It is, and I think you bring up a lot of good points surrounding why it could be problematic, but ultimately it is the supreme law of the land. And I also liken it a lot to our DACA clients that we have. You have an entire generation of people here who are now on DACA, and they don't have citizenship. They weren't brought here, but they came so young that they have really been raised in the United States. And if they didn't have work authorization and protection from being removed from the US, I think that you then have a bunch of people who are working for cash, low wage jobs, subject to being abused by their employers, taken advantage of, and really don't have a reason to gainfully participate in the US. And so, sort of a lesson there is if we got rid of birthright citizenship, then the policy concerns we had would switch a lot and would be problematic because it is sort of when you come and you're born here, but you're never going to have a right to be a citizen. I think that does really sort of inform how they act in the United States. So I think that's
exactly. I agree with you because imagine there are about 12 million undocumented people currently, according to statistics. Imagine if maybe a number of millions are given birth and all these babies end up undocumented. It's certainly going to be problematic. You have people who have no hand in what happened, and then they're just disadvantaged because of their parents. So I guess that's a good point.
Yeah, so there's lots of interesting policy considerations around this. I mean, I also, as far as citizenship goes, it's so complicated, which is one of the reasons I love bringing your topic here today, because one of the first questions I ask a lot of my clients when they come in is, let's make sure you're not already a US citizen. And I'm sure everyone on this CLE right now, and you yourself have dealt with a client who's lived here for many years thinking they're undocumented and they turn out they're a US citizen. And, you'd think it would be that easy to figure out, but it's not. I think it has to do with a lot of the rules that have changed as far as derivative citizenship and acquiring citizenship. And I loved your fun facts in the presentation as well, because I just myself read an article that there was a time when women who married foreign nationals lost their US citizenship by virtue of their marriage. Clearly that doesn't happen anymore, but like these rules do change. And I think what we thought would never be something that happened did. Also, when my dad naturalized, he had to give up his Colombian citizenship. He was not allowed to still carry it. And that's a rule that's changed now too. The US is okay with dual citizenship.
Dual citizenship, exactly. I'm a dual citizen myself. Very thankful because you kind of when you're from a place. I grew up. I was born and raised in Ghana. I have a lot of attachment to Ghana. I love the US as well. So it's hard to just give up one for the other.
Yes, and I certainly have a lot of clients who decline to naturalize because they're going to have to give up their other citizenship depending on where they're from, or all the attendant issues with wanting to go back to your home country once you're no longer a citizen and having to get visas and things like that. So It is difficult. Any last words, like any super interesting case that you've ever seen with the citizenship issues where it was a little off the beaten path?
Actually, no, I haven't been that privileged to see any crazy citizenship issue, but well, the story which informed this CLE. So apparently the woman gave birth, as I told you guys, 2 hours before they landed in the United States. It was on a United Airlines flight, and the woman is apparently I believe I heard that she was a resident. She's Ghanaian. I don't know her personally. I heard that she's a resident of Ghana, but again, it doesn't even matter because insofar as she gave birth on US soil, baby's a US citizen. I mean, it's a very powerful rule. Like it's amazing that, you could, because in fact, let me use my own personal story. When I came here, I relocated from Ghana to the US in 2016, and I delivered to join my husband, who's a US citizen. I delivered 2 babies even before, and 2 babies, and both babies were US citizens before I became a US citizen, right? So I was the last person in my family to acquire US citizenship. So I had a US citizenship husband and babies who are all US citizens, and then I'm not a US citizen. It's just interesting, that you can actually give somebody or somebody can acquire citizenship through your actions and you don't have it. So yeah, but no, I don't have any story with a client.
Yeah, I mean, I think that's really funny. And it's interesting how, part of immigration is family unity and keeping people together. Yet we do often find these different citizenship status, whether you can get it, when you can get it. And I think that's interesting. And I mean, there's so many good stories out there. John McCain was born in Panama. And I remember when he ran for president, that wasn't like brought up very often. That was the whole thing with Obama's citizenship and such, but that didn't come up a lot. But of course, he was born to U.S. citizen. So, and he was also born in the canal zone, so that had its own issues as well. I, a couple years ago, had a client who was in jail and he was going to be removed after he got out. And it turns out he was a U.S. citizen. So while he was in jail, we were able to file an N-600 for him, and we delivered it to ICE the day they went to pick him up. And he ended up being released just to the U.S. because he's a U.S. citizen, could not deport him. So that's interesting. That's one of the questions. And also with immigration law, I think it's also interesting too, like for naturalization, when my dad naturalized back in the late 50s, you couldn't vote in a federal election. There was a cooling off period after you naturalized. And that of course doesn't happen today, but he naturalized just like 2 days shy of being able to vote in the election when Kennedy won. And he regretted that his whole life. It was nothing he could do anything about. But as you mentioned with birthright citizenship, if we have concerns like paying for babies to be born here and issues like that, there are other ways to legislate those without getting rid of birthright citizenship. There's lots of articles out there on when Clinton won the presidency, again, that a lot of people got naturalized right before the election to kind of help him out. So, because we got rid of the voting rule, but lots of interesting stuff. So before I end, two more things. One person asked if we could post a phone number for any issues on the topic. Is your information at the end of the slides, correct?
Yes, I think so, but I don't believe I have my phone number listed. I just have my website. So my phone number should be found on my website, but I can send that to you in chat here. Yeah, let me just put this here. 02.
And while you're putting the phone number up in chat, I just want to, first of all, thank you for being here today. This was really interesting and it was a very good conversation. And I think we could just go on and on about talking about these interesting citizenship and naturalization issues. And even going back to your Supreme Court case, why could those parents not become U.S. citizens? And that's a whole nother topic too.
A whole nother topic.
Super interesting, but thank you for being here. I appreciate it. As I mentioned at the top of the CLE, next month, we're gonna have someone talk about past, present, and future of the immigration courts. And very tentatively, the month after that, we're going to have someone come and talk about immigration court best practices, how to practice an immigration court to the best effect for our clients. So we're arranging that right now. So I want to thank everyone for coming. I appreciate it. And I will see you next month.
Thank you so much for having me, Anna. Thank you everyone for engaging. I enjoyed preparing and delivering. I hope you guys benefited from it. All the best to everyone.
It was great. Thank you very much.
Thank you.